Um, Here we go with some more exciting YouTube videos by the professor. We're now in module 4, at least of the, as I've set this up in the spring of 2017. They tell me don't date your lectures um, because you're always, students will feel like, well, I've got 10-year-old content here. What am I doing about this? But one of the things we may find that the law changes, and this is an area that it does tend to change a little more rapidly than others, is an employment law. But it's been my experience over the years that the more things change, the more they stay the same. And this is particularly true in the law. The law grinds very slowly and moves forward very slowly. Even our latest election of 2016, which created a tremendous amount of tumult, we may actually see some retrenchment of law. In terms of employment law, we're likely to see quite a big change there. But let's go on to this anyway. Make sure, and I'm not sure if tortuously is that should be the correct spelling, but this is kind of a basic overview. We're not going to get way down into the weeds on much of this. This is kind of first impression stuff, but this is basically employment law. Do our students need to know this? We're going to be an employee. Well, you need to know your rights as an employee. You also need to, as a manager, know the rights of these employees. What can you expect? And so, let's begin with the basic proposition that most employees are at-will employees. I have taught at the University of Missouri St. Louis for 15 years. They could fire me tomorrow. I am an at-will employee. And for years and years and years, I struggled with the idea that they will fire me tomorrow, and maybe they should. I think we could easily go there, and you guys probably have proof of why we should. But there are nice parts about being at will. First of all, I can, as we used to say in the water well industry, spool them up at any time. Well, spool them up means pull the cable up, but spool, most of these guys traveled with a kit, and they would just spool all of their stuff together with a rope, and out they left. They could walk off a job, and there was no, hey, you owe me money, I had to go hire somebody else to replace you. No, it doesn't matter. Employer, same deal. We fire you, you leave, we don't owe you a penny. You don't have a right to this employment. Some people are going to argue that's a dated concept. As the republic expanded, mobility of workers was a very important thing. Others are going to say, why don't we have French type protections? A lot of business people are going to tell you there's a reason we don't have them, because you can't fire somebody in France. I can't remember who it was. It may even have been Airbus was reluctant to build a new French factory. No, somebody was trying to merge or something with Airbus. It was going to try to, and they were forcing them to build the factory in France. And the merger fell through because the purchasing entity wanted no part of French employment law. We can debate that for a long time, but an at-will employee, I can just say, I'm done, see ya, take my smock off and I walk out the door. We don't need to examine anybody's motives in firing. All right, any part in firing or leaving. We do have in the United States, and we can make arguments on both sides of this, some employment protection acts. My first impulse is to tell students about paper tigers. You may or may not know what a paper tiger is, but it's it's something that appears really fearsome. And, we can paint a picture of a tiger and it looks very fierce, but the reality is I can blow right through it. And maybe a better example is ordinarily at the beginning of football games, the team goes tearing through a big paper banner of its mascot. I went to Edwardsville High School. We are the Tigers. Same at Mizzou. It looks fierce, but you can rush right through it. So a paper tiger in the law it appears to give a lot of rights, but when we get right down to it, we see quickly that there are a lot of valid defenses to all of these things. So as we walk through them, kind of keep in mind that while you might be able to bring an action on discrimination basis, oh, they discriminated against me, there are a number of defenses, one of which is you didn't do your job, and we can document it. But one is eliminated the position. I'm not so certain this one's going to long-term stand the test of time, although it apparently has gained foothold in the courts. We just no longer needed that particular job, and we got rid of it. It kind of dovetails with valid business purpose. I've seen a lot of businesses eliminate the title, but not really the work. The courts have been reluctant to peer deeper behind the veil. They've almost, it seems to me, I haven't read every last case in this, and maybe the plaintiff's attorneys have tried harder than I'm giving them credit for to say, look, they eliminated the position, but they just moved it over to Charlie. What we find in a lot of workplaces is there used to be 6 people doing the job that one person does now. We've just kept piling on more and more work on this one person. I've got a friend who works in a corporate office up in Chicago, and he's got at least 5 hats he wears all the time. He came in wearing 2 of them. One of the ones we can look at too is this a valid business purpose? Is the reason we didn't hire you or the reason we fired you valid under a real business setting? What this goes to is, was there an ulterior motive, if you will? And is that the acting basis, or were they really trying to do this on a valid business purpose? This may be a little fuzzy, and hopefully I'll get to some better examples later. The last one is discrimination on a lawful basis. And I think we can get this pretty clearly, but it has been upheld that Catholic Charities doesn't necessarily have to hire a Muslim, doesn't have to hire a Protestant. They can say, no, we really need a Catholic person here, a clergy. You don't have a right. We can discriminate based on religious background in cases of clergy, or so. Think about it a little bigger. We can discriminate against people in a wheelchair working hard labor outdoors. They physically can't do it. So, just things may appear on their face that we're violating some things. And a lot of students, it seems to me, have this idea, well, that's discrimination. Well, discrimination comes into narrow categories. And I think we need to look at that. I should have read my slides before we go. If we are to judge people by the content of their character and not the color of their skin, will continuous use of discriminatory determinants end the discrimination or keep it in place? The question I'm posing there is that we can't discriminate on the basis of race, But some of the ways we've gotten around this are that we do things like quotas. Well, quotas are not permitted. Um, and we're really judging people on the basis of their race rather than hiring the best qualified candidate. And sometimes the, the differences between the 10 people we may get to as finalists and the person who last won are kind of hard to put your hands on. Um, you know, are we going to judge that on a surface characteristic? Um, Not that that's the only determinant. A Muslim's skin is a different color than mine ordinarily. A person who's descended from Africans is a different color than mine. But I've got some odd color because I've got some Celtic blood in me. Anyway, I put a note in here that blind auditions, maybe we need to go to, we don't get to look at people. Pretty hard in, say, a sales job necessarily. I mean, if we look at sales, people who are more attractive tend to sell better than people who aren't quite as attractive. Somebody could we can, obesity, things like that pop into brain. You've got a continuous skin condition that people really shudder from. Are we permitted to discriminate? Well, generally, yes, because that is not something that has legal protection. Legal protection is race, color, gender. It says in the law sex, but that's a 1960s meaning. We mean gender. It does not mean gender identity. There may be a couple of state laws that have put this in place. They haven't really been fully tested by courts yet. I presume that they're going to allow it. But, one of the problems we get to is pretty soon we've got so many categories against which you can't discriminate that we've got everybody covered, you can't discriminate against me because I'm white. Kind of a weird thing. But in places where you can do blind auditions, such as the St. Louis Symphony Orchestra, the symphonies used to be all men, no women, zero. If you look in the 50s, you're not going to find women in the films. It's all men, with maybe a few exceptions, but very few. Now the St. Louis Symphony Orchestra is more than half women. It's really kind of interesting. Even the bass section has women in it. I don't think I've seen a woman percussionist, but that's about the only exception. Have I seen a woman? Sometimes the French horns are mostly men, but anyway, that's way off. This is just to give you some food for thought as we're managing. So what we're looking at, the major act is the Civil Rights Act of 1964. Was there discrimination? You betcha. You can watch all kinds of films, particularly the city of St. Louis, white fountain only, black fountain only, white restroom, black restroom, color people need not apply, plainly stated in the advertisements. St. Louis is the kind of a northernmost southern city and a southernmost northern city. It's a mixture. It's sort of like Cincinnati falls into this. So does Louisville. We have a lot of long history of discrimination, primarily on race and color. But we can also see religion. We've had a lot of anti-Catholic stuff, anti-Semitism, that is essentially hatred of Jews, has a long origin. It is, and some people say it's because if you look at Shylock and the Merchant of Venice, the only tribe, if you will, of people who were able to lend money were the Jews. The Jewish faith is the only one that permits it under their readings of their holy scriptures. Cannot, as a Muslim, lend money. There's a workaround. I'm sorry, I can't remember the title of it, but you can't have life insurance as a Muslim. Anyway, so you get this So the problem, of course, was the Jews could lend money. Well, they wanted it paid back. Well, then they get this, kind of snidely whiplash report or repute. So I think The Merchant of Venice is a sort of a tongue-in-cheek assault on the perception that Jews are all money-grubbing, nasty people. Just like some of the bad perceptions about people of African descent. Some of our greatest leaders, I don't know that Washington went in this direction, but Jefferson and Bobby Lee are the people, at least I know of, who, John Calhoun also questioned whether black people were smart enough to study. Well, fortunately, we gave them the right to get educated, and now we can see that that's absolutely true, that, this division of learning ability is much more a fate of not having been given opportunity for generations, which sets people as a class back for generations. We also talk about national origin, the Polacks, the Irish, Mexicans, anything like that. We get this kind of, it's not a happy thing, but this sort of Anglo-Saxon superiority that we're slowly moving away from. And here's an Anglo-Saxon speaker talking about you can't engage in this kind of thing. If that is your primary purpose, you lose. If you're trying to do it from a business standpoint and a valid business standpoint, no, you win. As long as you're color blind or sex blind or gender blind, you're going to be in okay state. Let me make another point that on federal law, at least right now, there is no protected class for sexual preference. During the Obama administration, the EEOC put it on the front page of their website that you cannot discriminate against people on the basis of sexual preference. Well, frankly, that's not the law. That has to be passed by Congress. Agencies do not have the power to rewrite law. And this debate's pretty heavy. This debate's real heavy because there's a whole bunch of people who want this kind of pen and phone reality coming out of the executive department. But that brings us back to having a king. That's what we tried to guard against in setting up the executive as the agent of the Congress. The Congress has to pass these laws, and they're hard to get through. And that's part of the design, is that in a democracy, change is challenging. That what we already have has worked okay. It's got to be pretty bad before we change it. I'm not saying we should never change. We're going to evolve slowly. We're going to always amend these, but we're going to tend to work around the edges as opposed to wholesale change. So anyway, state law, however, most of the states now, I think it's at least 28, it may be as many as 34, and again, we're spring of 2017, have identified sexual preference as one of these protected classes. You cannot say, I'm not hiring you because you're straight. That's not really a valid business purpose. So maybe what we ought to do as business people is go, all right, what are the valid business purposes? What do I really need in this job? Do I need to worry about some of these protected class deals? But at the same time, if I'm going to say, well, my customers don't like dealing with black people, that defense is gone. Wiped out by Heart of Atlanta motel or hotel, early Civil Rights Act case. No, you can't use a customer. That's just a way to discriminate, but blame it on somebody else. You're actively discriminating is how the law is going to look at that. It's interesting too that these also apply in housing and in education. So Title VII, Title IX, Title IX is you can't do this in education. We see a giant growth in women's sports as a result of the Civil Rights Act of 1964. Now, if you're going to have a men's tennis team, you likely have to have a ladies' lacrosse team or something like that, or a ladies' tennis team. The way they've worked these out is you got 8 guy sports, you got to have 8 girl sports. They don't have to be identical. Women football team, no, we don't necessarily have to have that, but we do have to have a gymnastics team, which, may be primarily women. What we're looking about is disparate treatment. Do we treat each individual different based on these things? Disparate impact talks a little bit more about class. As a class, have we had an impact upon these things? And women's sports may be sort of a decent idea. If we're in violation, here's what we basically have to pay: back pay and attorney's fees. All right. This is, I think it's worth a little more aside here. Attorney's fees is a fairly rare thing in American law, that we make somebody else pay your attorney's fees. Ordinarily, we are on both sides pay their own pay their own attorney's fees. What we find in the British system is that the winner pays. There's been a lot of debate over this over the years, a lot of push back and forth. We've come closer to going, no, the winner should pay attorney's fees at times, but it's never won. The argument has never been won. What we like in the United States is much more the ability to file. We'll give you broad ability to file lawsuits, and even to do so without much fear that you're going to have to pay the other side's attorney's fees. We would rather our courts begin to hear these things. Has that led to some of the downsides that we're complaining about on the right? That we've gone too far with class actions, all that sort of stuff, potentially. But if we look at the system of our courts, and our courts retain that rule of law thinking throughout our long history, as they've tended to, we've become more and more progressive, but give it some thought about whether that's all bad. I was just reading a very interesting article on Muslim extremism, where Americans were chastised because we make a lot of fuss over a mouthy current president, but make no fuss about Muslim governments that stone people for adultery. It just reminded me of Christ's words, "Let he who is without sin cast the first stone." Getting on a soapbox here, but maybe that's the difference. Is Christ, to me, reshapes the Jewish faith and does some modernization of it. And shortly after he spoke those words, stoning began to disappear from Judaism. And are we better off that we don't have people stoning other people for sins we all commit? I leave it to you. The old way isn't always the best way. We need to keep examining that. Critical thinking is thinking inside the box as well as outside the box. All right, so I think I may have already walked through some of this. Gender is generally protected in states. Gender is equivalent to sex under the Civil Rights Act. Pregnancy can be a determining factor because we're discriminating against women who get pregnant. There are jobs where we can say, no, you can't have this. We can't let you have this job because of the chance of you becoming pregnant. But they're going to tend to be pretty limited. And the courts are going to look very carefully at whether that's really there's really a concern for the safety of that individual, or if this is just pretextual. It's just a pretext to fake the fact that we just don't want women working here, or we don't think women can do this. Sex plus, gender plus status and class, are we discriminating against them for religion and other things too? Anyway, I'm moving here. I'm not dead positive what I meant by that. As I put it, we're in a different book now, so these are a little bit off. Now let's look, though, at sexual harassment. I like the British pronunciation. And there are two basic types, and this is not Civil Rights Act. This is stuff that's developed. It's very, very prevalent at the state level. So sometimes the federal law may or may not cover this. I think we need to be very careful as we're doing a lot of this employment discrimination law to know that we've got lawyers in place who keep us up to date on what's happening at the state level. I know that it's a failing of mine. I tend to almost ignore the states and focus on the feds. That's not necessarily a smart thing. The states have a lot of local power and exercise it. In sexual harassment, there are two major types. First is quid pro quo, which is Latin for this, for that. And hopefully you don't need too much imagination to figure out what this sort of thing is. It tends to be in the area of sexual favor, or certain conduct gets you certain things. It tends to be men preying on women, but there are cases where women have done things to men. They're, in my experience, pretty rare, but telling your secretary that I really like you when you wear those really short skirts, you don't have to dig too deep in there. This is basically saying you do this and I like it better, and then something good will happen for you. You do this, I make it better for you. You make me happy, I make you happy. It's kind of what they're looking at. Is it the weekend in the Adirondacks? It doesn't necessarily have to be. Some of what I'm talking about maybe borders on something closer to hostile work environment. The standard examples I know of hostile work environment are some guys, for some reason, like to have porno screensavers. They may or may not be explicit, but they're kind of generally, not in a public place. You want to do that in your little space somewhere, down in some hole, do it. But out here in the public, you can't. And particularly in the more and more cubicle environment of the kind of open workspace of today, which of course comes and goes, we've had people who, have hurt. They've just made it kind of, I don't really want to go into work there. Now let's look at the standard on both of these is actually, would a reasonable person be offended by the conduct and find that it created kind of a hostile work environment? It's not, was I personally offended? That's a standard we can hardly ever uphold in the law. First of all, we have to know, was my expectation reasonable? And reasonable, as we've said multiple times, isn't always defined. It's just kind of what would the ordinary person think under these circumstances. So it is sort of a search for a general social mores. We do have some affirmative defenses. The other one I wanted to add was, it's kind of an old statement that moving to the nuisance doesn't mean the nuisance has to change. For instance, if I buy land in Texas right next to a giant cattle feedlot, and the day I go looking, the wind is out of the west, and I can't smell that the feedlot smells pretty bad. And then I move in, and the wind is out of the east most of the time, and it smells like cattle yard all the time. I can't get that cattle yard to move. Same thing with, the one example I've seen, I'm not sure it's still that upheld, but, you walk into small repair shops, and a lot of times they have calendars up from Rigid and some of the other tool companies, and usually the pictures are pretty provocative. It's a bikini-clad girl bending over a carburetor. Not leaving much to the imagination, folks. They're not completely naked, but, so if we look at Richard Rawlings of the Fast and Loud group, the young girl that runs his office for him, I see he doesn't have any of these posters up, but then he's on public TV. But in a private workspace, she hired in, if the calendars were up when she hired in, she can't really get them to be taken down. So don't expect that I walk into this and I'm going to be able to change the native community. If, however, it is completely offensive to the reasonable person, the employer has less defense. It's a free speech right, but as we've talked about in other places, free speech isn't unlimited. There are some, defamation you can get sued for instance. Affirmative defenses, we've taken reasonable care to prevent this. Maybe we've got this guy's a nut and he has to have these pornographic screensavers up, blah, blah, blah. Well, maybe if it's one out of every 5 screensavers is a provocative picture, is that purely a hostile work environment, or are you looking to be harmed? Did we as an entity take reasonable care to prevent the behavior? The quid pro quo deal. Have we done the training in advance on the individuals to try to get them to not do this? Well, we as the employer might be able to get away from it. It's like, look, we did what we could to try to get them to modify this behavior. The man persisted in it. It's him, not us. Another thing we may find too is that sometimes we've got a system in place to notify us as a company, hey, this is uncomfortable. Can you do something about it? Can you look into it? Well, if the employee jumps straight to a lawsuit without giving us a chance to remedy, they may not get a legal remedy because we had an administrative remedy. The law prefers the simpler solution. Try to fix it in-house if you can. Don't just come screaming to us that, oh, this is a terrible travesty and we've got to fix it. No, lawsuits are big, they're expensive. Maybe if you had just called your supervisor and said, hey, John's got this screensaver. It's all family pictures, but then there's one picture in there. It's 12 of them. And, I don't see it necessarily every day, but I see it enough that it's pretty, well, maybe we'll go look at John's computer and see about that picture, blah, blah, blah. We can probably work it out in-house rather than let's go to federal court over this. Additional deals is there may be grievances you can file in a union setting, some of that kind of stuff. If you have not exercised your rights under a union contract or under an employment contract, you may be SOL in terms of ability to go forward with a lawsuit. At the least, what the court may go is, no, you haven't exhausted your administrative remedies, and therefore you need to go back in. Now, again, here we get into Are we now outside of the statute of limitations? Well, sometimes the courts are like, that's your problem. You've got to be on top of your own rights. And the fact that you let this linger and fester and did nothing about it administratively or waited till the very last minute to file in court, that's your problem. There were reasonable methods to get this solved without us being in court. I've got reasonable accommodations in here, and this is mostly Americans with Disabilities Act or Age Discrimination in Employment Act type of things. We don't necessarily have to rebuild our entire office space to accommodate somebody in a wheelchair, but if it can be done with minimum disruption, and it should be done. It must be done. Again, using the railroad as an analogy, a guy in a wheelchair cannot work track, cannot run a locomotive. Those are basic, simple job requirements. You must physically be able to do the work. You cannot. But if it's a desk job and it's only going to cause some discomfort to other employees or to the employer, we should try to go to reasonable accommodations. This is an area where we might talk about paper tiger a little bit here. But again, I think I already talked about the religious organizations and the exemptions. A Shiite Muslim mosque doesn't have to hire a Sunni. No. I live down the street from an Anglican church and a Congregationalist church. They get to pick who they want, and do we have the ability to say, hey, Muslims, you can't worship here? Yeah, if some church wants to go that way, they probably can. You can't force yourself into, it's sort of the same thing as ladies' tea clubs discriminate against me. I'm a man. But guess what? That's okay. It's a private organization. It is not engaged in interstate commerce, and therefore those rules don't apply. The same thing with Augusta National Golf Club. It's all men with 2 women exceptions. Condoleezza Rice and then a very prominent stockbroker from South Carolina. And they were just put in 4 years ago, and there haven't been any since. The president of IBM is now a woman. IBM has 5 memberships, as I know at Augusta National. She doesn't have one. Same deal at GE or GM. Kind of weird. Same sex. I'm not certain what I mean by that. This is one of the problems with going back over old PowerPoint slides. So we're going to skip that one. Probably what I mean is, can a man actively discriminate against another man? You betcha. Can we create a hostile workforce against another man? You bet. We could have a gay boss who's flirtatious with men. Who's doing, that actually happens. Just like we can discriminate against white people under this law. If that is our intent, we can be in violation of the law. We've got to recognize that this has a broader reach than they maybe first anticipated. I've already talked a little bit about this sexual orientation. I meant to check the website before I got in, but it used to be on the front page of the EEOC. First thing out of the box, you go to the main page and it talks about sexual discrimination in terms of sexual orientation being verboten. Well, that's not what the law says. The Senate passed a bill, and I can't remember, I think the Senate may have been Democrat controlled at the time, and it went to the House, and the House was overwhelmingly Republican at the time, and that bill went nowhere to add this in. We may want to look back historically. We had an equal rights amendment that got to, I believe, 28 out of the 30 necessary states ratified it, but the last two wouldn't. They couldn't get the next three to go. Phyllis Schlafly kind of came in and reset the table, and next thing you know, new elections happen. States are pulling back their ratification, and it just sort of died out there in the 70s. One of my big heroes, Betty Ford, was all for it, but it died. Is that? Let me go on to this slippery slope thing. Are we better off without these protections? I think it's a debate we want to kind of keep open, because the more we have government saying, here's what you cannot do and here's what you can do, and the less we have the people kind of deciding these things on their own through their own reasonable behavior, we get into this regulatory miasma. I know some of us think, well, no, you've got to be able to do that. I don't know. As a parent, the hardest thing for me to do is to not tell my kid, you got to do it this way. I got to let them skin their own knees to some extent. And are we avoiding that sort of societal learning? Are we avoiding the kind of union of, you really can't discriminate against somebody because their sexual orientation is different than yours. Maybe you should modify your behavior, but do we need a law to get there? The deal on a slippery slope is once you begin down a hill, it becomes really hard to stop. And particularly as the slope gets water to it, it loses friction, and pretty soon you're at the bottom. What you were trying to prevent, some people will argue, you got yourself right to it. So you've always got to be careful. It's kind of a caution, if you will, that we should take before we jump into legislation on anything. So here's some more defenses. BFOQ, bona fide occupational qualification. You have to be able to code in C++ in order to get this. It doesn't matter that you're Muslim in that occasion. It doesn't matter that you come from Poland. You either can or cannot do it. Okay? We can always look at merit, education, experience, testing. You didn't pass this. It has been, if we look at historically police departments, fire departments, we've had some difficulty getting African Americans to qualify. Now, some people have said, well, we need to change the test because the test is unfair. I don't want to open that one up. Maybe I will. But I've also seen things saying, no, this test has been dumbed down to a point where, we're not certain that this fire chief really can do the stuff that needs to be done. Think about a fireman. What do they have to know? They have to know how to put out a chemical fire. They probably have to know how to do life-saving procedures on a heroin addict, somebody who has had a heart attack, all kinds of stuff. So, we can get into some areas where we could discriminate. We could figure out a way. Well, the best way to keep blacks from working here is we'll put an experience limitation on this job. Well, what the court's going to look to, is that a pretext? Is that just a way to get around this? Or the court will look at it if a smart attorney argues, Judge, there's no real need for experience. This is an on-the-job time of entry-level job. They're just trying to discriminate by the back door. And so we're always going to be looking at that kind of stuff. All right. Seniority. Do we have the ability to discriminate based on you've been here longer? This cuts in many ways, but a lot of union contracts are built solely on seniority. You've been here this long, you get to keep it. That's one of the things that a lot of businesses are like, I hate the seniority clause, because what I tend to get is somebody who's kind of set in their ways and doesn't necessarily want to work as hard as someone who's 15 years younger. But I'm stuck with this guy because I made the mistake of hiring him 20 years ago and not getting rid of him. That's one view of it. The other is, worked here a long time, built up a lot of time. My family depends on me. You fire me, it's going back to the 1870s, where we just took injured workers on the railroad and threw them on the side of the road and kept building. And they had to find their own way back. It's kind of like Queen Elizabeth in her wars in Ireland and the Netherlands. All the ordinary soldiers had to find their own way back. The Queen brought her royals back, but she didn't bother to pay to get get the little people back. So as we're looking at this, seniority has some negatives, and I'm an older guy. I'm kind of sitting there going, I'm losing my energy. But I've also got some of these gray hairs, and some of my thinking through experience has gotten better and better and better. So while I'm internally debating, should I quit because I'm kind of tired, a lot of me is saying, you probably have 10 more years of useful life in this profession, and maybe you can help, and you can build your own forward. And of course, as you're watching this 10 years later, same video, you go, well, but he didn't change it. Part of that is because it's, at least for me, challenging under modern technology. I'll probably figure it out eventually how to change that. We've always got this valid business purpose excuse, but we're going to test that. Is this a subterfuge, or is it really a valid need? If we've listed it in the application, that may or may not be sufficient. It has to really be, this is a key component, communicates effectively. If we've got somebody who's got a terrible speech impediment, notice they're not part of the protected class, but, are we using that speech impediment as a way to get past some of the anti-discrimination laws? I think I'm on the last slide, so let me look. I hope I've covered this well enough. I think our general feel here, before I jump to this last slide, should be, what is my motive? Why am I favoring Neopho over Johnny? Am I doing this because when I look at our workforce, we don't have enough Asian Americans. We don't have enough, transplanted Canadians, whatever it is. Or am I doing it because I think this person is the best fit for our business? I hope when you do that analysis, you realize that best fit is going to hold up in law. If we can justify it step by step, if we can say, well, Neopha doesn't do this well, but here were 3 other things she did better than any candidate we had. And when we looked at David, he did that one thing really well, but he wasn't quite as sharp on these others. Neopha just had it kind of natively, and we had the sense from talking with her, she would actually get better at this and be able to teach it to other people, and that's something we needed. Or am I just trying to hire her because her skin's the right color? Here's a couple of deals. The Equal Pay Act is out there. It tends to be more state level. It's been up and down in the federal system. The enforcement's been questionable. I remember an article from our recent election that the losing candidates campaign underpaid women hugely. whereas the prevailing candidates program paid equal pay for equal work. Um, you know, should we be going there? Yes. If the reason supposedly historically women got paid less, and there's still some truth to this, a lot of women went into education, which is not a 12-month-a-year job. It sort of is, but not completely. I mean, you get summers off, and you can really just say, you know, I'm not working again until 2 weeks before August, and that's kind of what my mom did. She did a lot of other work, but in the month of June, she was just, please give me a month off. I gotta just get away from this. Um, um, anyway, the next one is, you know, and so women were not, or they were chose secretarial roles because generally a secretary at 5 o'clock can leave. The boss can't. The boss may go, okay, now I can finally get some work done. Everybody's out of here, and would stay till 10. Um, you know, there was a reason I, as an attorney, made more money than the secretaries who were all women. You know, my firm, when I first came in, didn't have any women. When I left, we had one. I don't know where they are now with that. You know, we were seeing a slow change in gender. I think the law is getting very close to about even men and women. And we paid women the same thing. You know, their entry pay was the same as my entry pay. We didn't discriminate on that basis. Let's look at the ADEA, Age Discrimination in Employment Act. And in many ways, this is one of the biggest paper tigers. Because if we look at who's getting downsized in almost every firm in the United States, particularly the 2008 crisis, who got fired? Well, we didn't necessarily fire them. What we did was we severed them. We gave them, here's a year and a half pay, here's a 5-year health care plan that'll get you at or near Medicare. Here's a bonus paid into your 401k plan, and here's the document we want you to sign. And that document says you have all these rights under all these discrimination acts and blah, 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 but by accepting this package, you agree you will not sue us. Is that possible? Is that reasonable? Yeah. You know, are the courts going to come in and go, no, class action, we're getting rid of this? No. You know, here's part of the beauty of it. All we have to do is kind of modify the offer to anybody, negotiate the offer with anyone, and all of a sudden we can get rid of the class action. Well, we can't get rid of it, but we can minimize the chance of the class action because we're going to have all these things. All the claimants aren't going to be similar enough that a judge is going to go, yeah, let's bring these together because you've got 500,000 people laid off and half of them got X and a fourth of them got Y, and another third got Z. Pardon that. Just realized I've got a device I got to plug in for a second. I should have waited. I'm at the end. But I would have to admit that as we get older, we lose productivity. We gain wisdom, but in some jobs, that's not necessarily a big deal. A wiser locomotive engineer may or may not be better than a younger locomotive engineer who has better reflexes and ability to get in and out of the locomotive and throw switches or whatever else there is to it. You know, so this one, I think we should look at it as, what is our motivation here? Are we treating these people who've worked for us for a long time well? Can we look ourselves in the mirror as we go out? I should have known these were here. The Americans with Disabilities Act, 1991, very much needed. We went from about 1.7% of population with disabilities employed to, I believe, as high as 4.1%. Still not, you know, as big a portion of the workforce as we may have thought. But as you can see, there's a lot of exceptions to the need to accommodate. What we're looking at is under the Americans with Disabilities Act, if you have two activities of daily living that limit you, you may qualify as disabled. And I know I'm going to conflate this with the ADLs under home health care or extended care insurance plans, but it's things like mobility, able to dress and undress self, continuous pain, a lot of the ADEA, can you function mentally? The fact that somebody maybe is on medication in order to keep them working, say somebody with ADHD who needs to take medication, well, it has some negative impacts as it goes on. Are we able to reasonably accommodate them so that they can continue to do their job? A lot of state statutes, particularly the workers' compensation statutes, talk about retaliation, that we will go after you because you do have these disabilities or you have this, you filed against us, we're going to retaliate back against you. A lot of state action, because let's say you get hurt on a job, workers' comp, and you come back and guess what? You're not doing that job anymore. You're doing a scut job. We just knocked you down about two pegs. Or I made a claim under the ADA that they weren't accommodating me. And so they accommodated me for 3 months, and then they decided to change my job description and do something else. Be careful out there, employers. There are some laws with some teeth to them, not paper tigers, that say you can't do that. And so what they may say is, yeah, you can put them in that lower job, but you got to pay them for what they were doing. And that sort of wakes you up to the employer. If I'm paying for it, maybe I ought to get the work out of it. Last comment, I think, is affirmative action. Quotas are not permitted. Bakke, B-A-K-K-E, is a fairly famous case in my lifetime. A young man was able to sue the University of California, Davis for not getting into medical school. What he was able to show was that he was discriminated against on the basis of his color. Guess what color he was? He was a white guy. And what he showed was that the standards had been lowered for African Americans. Now, my aside to that is when you take a class of people and make it a felony throughout most of the country to educate them for 250 years, yeah, guess what? You don't produce highly academic people. I'm a product of my parents. My parents are highly academic people, lots of education, and so you've got other people who, you got this citizen class, if you will, that does low labor jobs, that is, put down, not able to talk back to anybody, not able to engage in independent thought. That creates some big problems. And it has historically created giant problems for a large class of people. And it's, you guys may never have heard the phrase uppity nigga, but what that was when I was a kid was somebody who actually had the guts to stand up for themselves and happened to be black. They were uppity, okay? That takes a while to get rid of. The idea of affirmative action, and we've been in it for almost 60 years now, which is basically 3 generations, maybe just 2, if we count generations as 25 years, as opposed to 10 generations or more of discrimination. Because really, the House of Burgesses in Virginia passed the slavery law, I believe, in 1619. The slaves were freed by the Emancipation Proclamation. But let's look realistically at what happened. That freedom is still limited. In the 1960s, you can look at pictures of St. Louis in 1965, and that's when Bill Clay, Congressman Bill, who became Congressman Bill Clay, who unseated an IGO, I believe, um, led the sit-down strike against Jefferson Bank and Trust, because even though 30% of the bank accounts were held by African Americans, nobody who worked at the bank was black. Nobody. This is what we're battling against. Should we use quotas? I'm not certain. Do I, as a white person, periodically get upset that, someone with a different skin color seems to have advanced beyond me, potentially based on race? I can't say I'm immune from that, all right? But I try to back myself up and go, let's have an understanding that my skin color always had preference at the hiring line all these years. It's always been easier for a white male to get a job. I know I'm on a rant here, but this is what we're trying to work on. How do we get there better as a society where we're not, maybe we're not judging people by their heritage or their skin color or their religion. I came out of Brazil as a young man and came to the United States and thought I was going to be coming to Xanadu. And what I found was a nation rife with segregation and some hatred. And some, I'm glad the tone has changed dramatically. When I came here in the 60s, right about the time this was passed, a lot of my friends and neighbors said some mean stuff that I thought, whoa, where did that come from? And it's just old prejudices that kind of die hard. We're always up against this sort of, well, those Irishmen took my job. Anyways, we listen to all the rhetoric about global nationalism and everything else. And as we walk through this, these are really old debates. They're always going to be here. But what do we as a business person want to accomplish inside our organizations? Where can we help our organization through this thought process? What's my role in it? What am I seeing when I look in the mirror? What am I seeing when I look at other people? Do I categorize people? We could do this protected class stuff, or do I categorize them in an improper method? It's kind of what Seneca advised. I believe it's also the 10th step in Alcoholics Anonymous. Take an inventory of yourself every day and see what you did right. I think John Adams did this. John Quincy Adams definitely did it. What I did right, I want to write down so I remember that. But what I did wrong, I also want to write down so that I can maybe remedy that tomorrow. So anyway, very long lecture, hopefully worthwhile. An hour of this is quite a bit. Thanks for listening. Take care.